2.5 years. And how they did Zoom presentations on law, I don't know, but they did it successfully. And so we're grateful to have them return in person to Central DeKalb. Many of us have gone to them and asked for advice. They're very helpful. So I don't know, I'll introduce you, but you can really give them the background about who you are, what you do. But they've been our community partner for 4 or 5 years, I'm thinking, maybe longer. I think that's right. Deanie was here in the beginning. With Rebecca started. That's right. That's right. Deanie Quillian. Try. And Lori Busby. So let's welcome them and thank you all for coming.
Thank you. It is so great to be with y'all in person. We have missed this opportunity, and so we're really grateful that things have improved and that safety precautions allow us to gather together. And we hope that we're going to be able to provide you some beneficial information. And we are here representing our team. So we have a team of 5. Our other partner is Rebecca Godby Cummings. She also does estate and probate work, and she also will act as an independent fiduciary. So if you do not have someone to name as an executor or as a trustee, she will often act as an independent fiduciary. And then we also have Chandler Stutzman, who is our newest associate, who has worked with us for several years while he was clerking in law school, and he has joined us. And then Keelan Roper, who many of you have met, is our practice manager. And so she sends her regards as well. We operate as a team. I'm Deanie. I joined Rebecca almost 4 years ago. I came from a background in fiduciary litigation. So I was on the other side, resolving family disputes. And I much prefer the counseling aspect of this practice and doing estate planning and probate administration and trying to think of ways when we're working with clients and developing their estate plan to avoid conflict. And we'll talk a little bit about that today as well, and some of the reasons, some of the ways that you might want to update your estate planning to avoid conflict. So I'm going to turn it over to Lori.
Good morning. Can everybody hear okay? No? Okay. Is there anything we turn the volume up? Sorry. Thank you again so much. Let me reiterate what Deanie said. It is so great to be back here in person and seeing everybody and putting faces to names from the Zooms that we've done. And shout out to Victoria for keeping this going during the pandemic. I mean, really, it's been fabulous. It's just so great to be able to be a part of your program. So I joined Rebecca and Deanie and Chandler. Well, Chandler is most recent, but I joined them about 2.5 years ago. I came from a litigation background as well, and my focus was on insurance. So I helped people with their property insurance claims and liability insurance claims and fighting with their insurance carriers. And as you can imagine, that was a frustrating endeavor. So switching to the estate planning practice, I agree with Deanie wholeheartedly. It is a much nicer way to practice law. And I just love the ability to work with folks in making sure that their estate plan is exactly how they want it and setting it up so both of us are very dispute conscious. We definitely, having been on the litigation side, see the fights and see how things can go wrong. And we bring that experience to the estate planning practice and helping people make sure that when they're gone, that their family isn't left in the world of dispute. So we're going to start off, we'll go back and forth. We've got a variety of topics. Our title today was, is it time to update your estate plan? And part of what we wanted to talk about a little bit was legislative updates that have happened in the past 2.5 years. Surprisingly, there have not been that many changes. So we have a few things to talk about specifically that have been updated, and also some comments about when you might think about updating your estate plans if you already have one in place. And then we should have some time at the end if any of you have general estate planning or probate questions that you want to ask. To the extent they're not very fact specific, we can address kind of some general questions, and then you're always welcome to contact us and reach out if you've got more specific issues you want to talk about. So with that, I will turn it over to Dee Dee to get us started.
Thank you. So, since it's been a while that we've met in person, the major change that occurred in 2021 was that the Georgia legislature passed an official statute that now allows you to create a personal property memorandum that can be left with your original will that is now legally binding. So we passed that form out to you so you can take a look at it and we can describe that to you. Before, if you left a personal property memorandum, it was not legally binding on your executor to follow your wishes. It was your desire that they do so, but it wasn't legally enforceable on your executor. This new statute allows it to be legally enforceable and at the same time provides a huge convenience and benefit to each of you. And that this is a document that you can create on your own. You can update it from time to time as your circumstances change or if family dynamics change. And as long as you execute it properly and leave it with your original will, then you have that peace of mind that as to your personal property, your executor will follow those instructions. So it is a document that is intended to go hand in hand with a will. So if you have a will, you just want to check and see if there is a provision in your will that states that you may leave a personal property memorandum. So with this document, what you would do is you would execute it by filling in your name and then giving a very specific description of the item that you want to leave, an idea, location of where it is, whether that's in your living room or your dining room china cabinet, and then the full name of the person that you want to leave it to. We always recommend don't put to my niece Caroline or my friend Kathy, leave the full legal name. And then at the bottom, you will sign and date it, and you want to do that in blue ink is what we always recommend to make it more easily identifiable as an original with your original will. So what types of things can you leave on this personal property memo? Anything that is tangible, movable, personal property. So that is things like jewelry or clothing or furnishings or artwork. It does not include intangible property. So no stocks, no bonds, nothing of, that would be considered a monetary gift. And likewise, you cannot leave cash in your personal property memorandum. You can't say I leave $5,000 to my niece. That can be deemed to invalidate your will. And so this is a very limited use for this personal property memo. So why do you want to do this? We find in probate work that often the disputes that arise most often among heirs are with regard to the personal property, the family heirlooms that, you know, all three children want, or one child believes that it was promised to him and another child believes that no, mom said I could have that. And so going through this exercise, while it can be a little labor intensive, often leads to peace within the family when someone dies because they know that these are your specific wishes. So we highly recommend you having discussions with your family members about what family heirlooms they are most interested in. We've even advised clients if they have an estate with a large amount of tangible personal property, that they might oversee a sort of a round robin game where they gather the family together and the children take turns telling mom or dad what items they're most interested in. So these are just some things that will make probate go a little bit more smoothly. Does anybody have any questions with regards to the tangible personal property memo? So it's contemplated that you'll have a will that goes with your tangible personal property memo. The nice thing is that this tangible personal property memo can be executed at any time. So as long as you have a will, it can be executed, 2 years later, 3 years later. There's no time limitation on it. And it can be updated from time to time should your beneficiaries change or should your personal effects change in how you want to distribute them. So what your will probably says, and I just want you to check it, is that you may leave a personal property memorandum. If your will does not indicate that you may leave a personal property memorandum, then that would be something that I would recommend you have just a update to your will done. Can be done by a simple codicil, which is just an official amendment to a will that's executed with the same formalities as a will. But you would want some kind of reference in your will to a personal property memorandum.
Can you put a vehicle, car?
You can put a vehicle on here as well. So vehicle, furnishings, artwork, jewelry, those are generally the type of items, but no accounts, no stocks, no bonds,
No real property.
no real property.
So no, your house, no.
Yeah. It has to be movable, have to be able to pick it up and move it.
They have to be witnessed.
It does not have to be witnessed. So it just has to be signed and dated and the original left with your will. Yeah.
So coins.
Coins, it depends on the value. People ask me all that time. It does contemplate collections of tangible personal property. But coins, if it's a valuable collection, if it's a few coins, I think that's fine to leave it in the tangible personal property. But if we're talking a coin collection that has significant value, I would leave that through a bequest in your will.
And just to add to that is if you create multiples of these and you, let's say you do one tonight, you go home, you fill it out. And 6 months from now, you decide, oh, wait, I'm going to do another one. And your executor finds multiples of them with your will. They'll honor them all. And for any conflicts where the same item might be listed on multiple ones, they'll just use the latest dated one. So it's fine for you to have multiples of them. Just know that if you have given the same thing to multiple different people, the latest dated memo is going to control with regard to that.
Where can you get extra copies? If you do?
Oh, of the form?
Yeah.
Just you can contact us and we'll have you to email you a copy. We'll email it, I think, to Victoria, so she'll have it in her forms file, and so you can just ask Victoria for it.
So while this was not a recent update over the past 3 years, it's an update that's worthy of talking about. Back in 2017, the legislature here in Georgia created a statutory form power of attorney document. So many of us have had our wills prepared years and years ago and haven't done anything with them. And probably as part of your will package, when you had it prepared a while ago, you would have had a power of attorney produced as well. Well, if it was before 2017, July of 2017 exact, and you had a power of attorney done before that, your power of attorney is still effective and is likely still valid. But the new form that is being used is one that has to be accepted by financial institutions absent evidence of fraud. Historically, lawyers created their own different versions of the power of attorney form. So banks would see varying types of documents that would come into them that would express somebody's desire to appoint somebody as their agent, as through the power of attorney. And just to be clear, the power of attorney is the document that allows somebody else to step into your shoes and handle your financial affairs when you can't, or when you are out of, when I say can't, that doesn't necessarily mean for health reasons. It could be if you have an immediately effective power of attorney, it's you're out of town and something comes up and you need somebody to go to a bank or to go to another financial institution and do something for you. So the power of attorney controls finances. And if you have a form that predates 2017, I would recommend that you have your estate planning lawyer or have us take a look at it and make sure, see whether you need to update it or not. Not only do you need to update it from time to time because your agents may have changed that are in the document, but now that we have this new legislatively created form, it has more information than the older power of attorneys had. For instance, for each one of your agents, the form includes their addresses, phone numbers, and emails, which is important for the agency that's accepting the power of attorney to have that information so that they can go back and contact the agent if they need to. The older forms, people just inserted names, said I'm making Karen Smith my primary agent and John Smith my backup agent. Now there is the primary agent's full contact information is listed as well as the backup agents. So I will just encourage you, and I have a copy of the form with me if anybody is curious as to what the new form looks like. Attorneys modify it slightly, but it really follows the same format because it's taken from a Georgia statute. So you can take a look at it and say to yourself, does this match what I have? And if it doesn't, then maybe it's time to talk to your estate planning lawyer about getting an updated form. The other form that was modified at about the same time, I think it was 2016 versus 2017, was the Advanced Directive for Healthcare. There used to be a durable living will that created agents for who could speak for you in the event that you had a health issue and you couldn't speak for yourself. Well, the legislature has also created a form that is called the Advanced Directive for Healthcare here in Georgia. And it is a form that identifies who your agents are. And it also has a second purpose where it explains what your choices would be in certain limited end-of-life situations. So it gives some direction about what your treatment desires would be in certain end-of-life situations.
Now, these are state specific.
They are state specific. And I can't tell you that they wouldn't be honored if you were out of, let's say you go to Florida for the winter months and you had that document. I think that it would carry some weight. I can't tell you for sure that they would 100% honor the document, but generally speaking, it's better to have them than to not have them, for sure. So, and with the healthcare directive, that's the one where we recommend if you come into our office and have a healthcare directive done, we tell you to sprinkle it around with every doctor you go see. If you go in for a treatment, bring it with you. If you have a patient portal, to upload your healthcare directive on that patient portal, make it as accessible as possible. Give copies of it to your agents so they have it in the event that something happens to you. One of the other things that we've started doing since the pandemic is we have healthcare cards that we give our clients that identify who their primary and backup healthcare agents are, and we recommend that they put that in their wallets behind their driver's license. So if something happens to you, normally the first place a first responder is going to look is let me find their driver's license. They'll find that card behind there, so they have contact information for your healthcare agents. So there have been minimal modifications to the healthcare directive in the past year. But most of that has to do with accommodating a totally separate form that is an advanced directive with regard to psychiatric care. Because the healthcare directive itself does not allow your agents make any decisions for you related to mental health issues. Institutionalizing you, committing you to a mental health program. That the form as it existed prior to July of this year basically said that this form does not cover those things. Now it says this form doesn't cover those things, but there's an advanced psychiatric directive that may take, may control with regard to those things if you fill it out. And Deanie's going to talk to you about that psychiatric directive here in just a minute. So let me open it up. Does anybody have questions with regard to the healthcare?
I have a question backing up the power of attorney thing.
Yeah, sure.
Is that something that has to be given to your financial institutions in advance, or you can send it at need?
Great question. So what happens with it is you keep the document in a safe place. As you can imagine, a power of attorney is a very powerful document for somebody to basically come in and stand in your shoes and go to your bank and make transactions on your accounts. So we recommend to our clients that they keep it in a safe place. They tell their agents, you're my agent on my power of attorney if I need you. This is where the document is if you are called upon to act for me. So they're going to hold on to, you're going to hold on to it yourself. And then, and you don't have to give it to your financial institutions. In fact, we don't suggest that you give it to anybody until it's really needed. And then there's options for the power of attorney as to whether it could be, whether it's immediately effective or whether it's what we call springing, which if it's springing, that means that you've said that you want a doctor to certify you are incapacitated before somebody can use your power of attorney. So oftentimes, I would say probably the majority of our clients, and Dee, I don't know if this is your experience, but the majority of clients have their power of attorney immediately effective, at least for their spouse. So that if they're away or if their spouse needs to handle something, their spouse can step in and use the power of attorney to do that if it's not a joint account. And then for their backup agents, it really depends on your level of trust and relationship with people that are serving as your backup agents as to whether or not you want a doctor to have to certify capacity or not. A power of attorney is a really important thing to have, particularly if you anticipate or you're under treatment for issues related to dementia or other mental capacity issues, because you'll want to have a power of attorney in place before a doctor says that you're incapacitated. Because if you're incapacitated, you can't execute one. You're not competent to execute power of attorney. And that makes you subject to people taking advantage of you if they try to get you a power of attorney at that point. So it's really important, if you don't have a power of attorney as part of your document set now, that you consider getting one so that it's in place when you need it.
Does it behoove you to get more than one? The resident have a family in two different places. Yeah.
It's one document that you could share a copy. A copy is just as effective as an original. So that's a great question. Oh, I see. So using that Florida and Georgia example, and if you're in Florida, you have a power of attorney in Florida, and if you're in Georgia, you have one here. Or the healthcare directive. It wouldn't hurt, I don't think, as long as they're not in conflict with each other, so that you have different agents in both places. And then let's say you have two kids and you had one as your primary agent in Florida and one as your primary agent in Georgia, and your child in Florida wants to make the decisions, but you're in a hospital in Georgia, then they come waiving this document. If they are the same, your agents are the same, I don't necessarily see as much of a problem, but I could see it being a problem if you decided, because this child is in Florida, I'm going to have them serve, and this child's in Georgia, I'll do a different one here. It really doesn't matter where people are these days. Between the internet and cell phones, everyone's reachable. So really what the hospitals need is a voice, a phone number they can call, and that's why it's really important in the document to have the full contact information for your agent so that they can be contacted when needed. Any other questions on that? A few more, okay. Go ahead.
What would you say for the name of the school? Immediate effect?
Oh, springing, right. It's basically a doctor's certification of incapacity. So just like the season, spring, yep, spring, exactly. Go ahead.
But for instance, if you have a DNR and your DNR says CPR only, or the EMTs or whoever, are they obligated to honor just that CPR? Nothing else?
To be honest with you, it depends on the document, I think, as to, because the advanced healthcare director,
Very specific for that.
right, there are a few other documents beyond the healthcare directive that are like your doctor would sign off on, and I forget what the initials of it are. I keep wanting to say it's the SPLOST, but that's the special interest tax. So that's not it, but it's something like that. And it's a form that you fill out with your doctor where you have a discussion with them and they actually sign off on it and agree that this is your medical treatment plan. A DNR at a hospital is specific to, I think, that institution as versus your healthcare directive. If you have it, is going to be, you can take it anywhere and any of your treaters will know. And as long as your intentions are expressed in the same way on both forms, then there wouldn't be any confusion. Most important part of the whole thing, and maybe let me not leave this out, is to have the conversation with the people you name as your agents on those forms and make sure that they understand what you want and that they are willing to honor what you want. Because if you name your kids and you have a conversation with them and say, this is what I want, I don't want CPR, or I don't want to be on a ventilator, and your kids are not capable of honoring that wish, they're not good agents for you because they're not going to do what you want them to do. So it's a matter of, if you have that form, it would not hurt to have the advanced directive as well. But as long as your intentions are uniform throughout, then you probably are not going to have an issue, or your kids or whoever your decision makers are not going to have an issue. But if you've got forms that suggest different types of treatment and there's a conflict between them, that's when an issue may arise.
Someone asked the question, could you repeat it, please?
Oh, absolutely. I'm so sorry. Absolutely. Okay. And does anyone else have any other questions?
This is something that I know, I'm not saying this is accurate information, but I have read where it's not unusual for doctors not to honor the healthcare directive. Even if they understand what's in it, you want sometimes the level of ethics cause them to feel like they need to get to a certain treatment. So is that kind of true, or are there repercussions if doctors or hospitals wishes?
I actually don't think that that's true. I think the harder issues where medical ethicists become involved is when people don't have a healthcare directive in place. If you have a healthcare directive in place, as long as the agent that you've named, and this could be the issue that comes into play, is communicating with your doctor, and the doctor's making a recommendation that's consistent with your wishes in the healthcare directive, and your agent's willing to abide by your wishes expressed by you in that healthcare directive, then I don't think there's any conflict. I could see a conflict where the doctor is making a recommendation that's consistent with your healthcare directive, that your family's not quite ready to implement your wishes, that then a medical ethicist becomes involved on behalf of the hospital just to work out that conflict. So, yes, ma'am.
Did you say to go ahead and give your power of attorney and your healthcare directive to the agent ahead of time or not?
So for your healthcare director, we say, yes, absolutely give it to your agent as well as your primary care physician, any specialists that you see regularly. And now with all the healthcare systems having these online portals, you know, Piedmont has theirs, Emory has theirs. Once it's uploaded by one of your physicians, usually it's within your portal for that specific facility. The power of attorney, if you're giving an immediate power of attorney to someone, it's fine for them to have a copy of that power of attorney. Usually that's for a spouse. If it's for a child, that's your option, whether or not you want to go ahead and give them a copy of it, because a copy in Georgia of your power of attorney is as effective as the original document. So if you feel comfortable going ahead and giving them the power of attorney, that's your discretion. Or you can just indicate that you have named them as agent, and if something happens to you, please look for my folder located in my filing cabinet, or look for the lock box that's under the bed, that type of situation. Yes, ma'am.
If you give someone power of health decision, and you're unconscious, and they're following those, and then you become conscious, and the facilities are there, do they have a right to go back to what you said you wanted? Maybe you changed your mind and you now want, but they can't.
Yes, so this is a great question, and I'll just repeat it. She said, in the event that you're unconscious and not able to make decisions for yourself, and your agent is making those decisions, if you then become conscious and are awake and alert, can you change your mind about those decisions in the healthcare? Yes, absolutely. As long as you're able to communicate your treatment wishes with your doctor, you are in control. You are in control regardless of what your healthcare directive says. Okay, you can change your mind at any time. You can revoke your healthcare directive. You can execute a new one. So the healthcare directive really comes into play in very limited circumstances, when you cannot communicate for yourself, when it's an end of stage life scenario that is a disease that is both incurable, irreversible. You have a very short time to live. That's one of the conditions. The other condition is when you have had some kind of traumatic brain injury, or something that has made you in an unconscious state, which is permanent, which is also incurable and irreversible. And you always have two doctors having to make these certifications before your healthcare directive is put into place. Any other questions on the healthcare directive? So, yes.
Person has been adjudicated incompetent. Does that same thing hold true, that if they can communicate with the doctor and they're saying things that they are legally incompetent? Does that still hold?
If they've been declared by a court of law as legally incompetent, then the healthcare directive, the agent, as long as that healthcare directive was executed while the person was competent, is going to control at that point, which sort of is a good way to get into the next legislative update. And that is that as of July, Georgia now has a psychiatric advanced directive. So this is a huge step for people that suffer with mental illness, and being able to execute one of these healthcare directives to be able to give direction and consent for the type of treatment that they would want in the event that they have a mental health crisis that may call for either treatment or even hospitalization. As Lori alluded to previously, the previous and the Georgia Healthcare Directive, just the general healthcare directive, does not allow your healthcare agent to act on your behalf for a mental illness.
Now we have this Georgia psychiatric directive that does allow someone who has been diagnosed with some type of mental illness and is receiving treatment, or has been previously hospitalized and has received mental treatment, to fill out a directive while they're competent and able to give direction as to specifics with regard to their treatment. So what type of medications they would want to be used, what type of medications they know that they've had contraindications, meaning that it has not been helpful or has caused a bad side effect. You can indicate that. You can indicate your preference as to where you would want to be treated should you need to be hospitalized, or to the contrary, where you would not want to be treated if you needed to be hospitalized. It is a very extensive document. It's at least twice as long as the normal healthcare directive. And the other unique part of it is that when you name an agent in this healthcare directive, your agent actually signs as well, accepting this appointment, because it's a very powerful and important document to be used for somebody if they have that mental health care crisis. So, so what's important to know about this is that this document is now available. So should either you or a family member have suffered in the past or are currently under treatment for a mental health issue, you want to have discussion with your family about this. And would it be appropriate for you to execute this new Georgia psychiatric healthcare directive? A couple of things to think about as far as naming of agents. You could not name your treating physician or your psychologist or your psychiatrist as your agent. That is a limitation. It would need to be a family member or someone that you trust. If you have a family member who is a doctor and is even a mental health doctor, if they're not your treating physician, it's fine to name that family member. That in all other circumstances, a mental health doctor would not be named as your agent. It again can be revoked at any time. So if you have a change of heart in the instructions that you're giving under this new psychiatric healthcare directive, you can revoke it and update it at any time. Does anyone have any questions with regard to this document? Okay, if you have any questions later, feel free to reach out to us. As I said, it's fairly new, it was just passed in July, but everyone.
Can you hear me?
Yes, ma'am.
I have a quick question. I hope you can help me. I was advised to consider making my bank account POD by naming my daughter, but I do have a will, but this is mainly a paper that says non-probate transfer on death, TOD account registration, request form and agreement. Is this in order?
So that's a specific question. What she's asked, and some of you may be familiar with this, is should she execute a POD, which stands for payment on death, for one of her accounts? And so that depends on who's asking you to make that beneficiary designation, because that's what a POD is. It is a beneficiary designation, just as if you had a retirement account and you were naming beneficiaries. A POD, and that is usually for a checking account or a savings account. You can also have what's referred to as a TOD, which stands for transfer on death. that is a beneficiary designation used for a stock brokerage account. So, it is a way to avoid probate, but you, need to be comfortable with signing that payment on death. And if it is, for example, if you have an only child, it would make a lot of sense to name.
It's
your
only
only
one child. It's only
Yes.
one child. No,
So-
no more.
Right, so if you have one child and it's your wish and your desire that you want that child to inherit your assets, a very effective way of transferring those assets to your only child is to execute a POD or TOD,
Right.
beneficiary designation on your account, and that avoids probate for that asset.
Okay, because
That's a good question.
he sent me a form that said non-probate transfer on death TOD account registration, request form and agreement. I haven't signed it yet, and I have to send it back to him. But I wanted to make sure that this is done because I thought that with just the death certificate was enough, but this is to avoid the probate.
Yes, and we're happy to, if you want to contact us, to look at that form just to make sure that it's doing what you want it to do.
Yes.
I'm always nervous about telling somebody to sign a form that I haven't seen, especially with all the fraud and the scam that occurs. But if you want to reach out to us, Victoria has our contact information and we're happy to look at it for you.
Okay, thank you very much.
You're welcome.
I've had my child, her name added to my checking account and her name's printed on my checks. Is that good enough or?
That's a great question. So often there are two ways you can add a child to an account. One is they can be an authorized signature only, which means that they are authorized to sign on your behalf, but that they do not have any ownership interest in the account. The other way is if you name your child on the account, they would be a joint account holder, so that upon your death, that asset, that account would transfer automatically to your child as the joint account holder outside of probate. Okay. And then the third way, of course, is with this beneficiary designation that we just talked about, putting a POD on your account to your child or TOD. Yes, ma'am.
So you have a joint or POD, and you don't have to very, the managing area.
So what happens is that upon your death, the joint account holder or the beneficiary on the POD would go to the bank with a certified copy of your death certificate and with their information validating that they are the person named on the account, and then the bank would transfer that asset to them.
I just had a discussion yesterday with a friend about that payment on debt. And I had always thought you could do that so that your agent could pay your bills and, you know, without waiting for the will to be probated. But she said, no, we just what you just said, that that person, that's that person's money and they don't have to use it for anything but whatever they want to. So how do you ensure that your bills get paid, you know, in the meantime?
That's correct. So it would be an understanding with your child that you would trust them to do that.
Right.
I want to give just two examples of why you might not want to make your child a joint account holder on a large account. I think it's perfectly fine on a small account so that they have access to some immediate funds. And I'm going to get Laura to weigh in on this as well. But for a large account, why would you not want to have your child as a joint owner? One, if your child has any creditors, that subjects their creditors to being able to seek those assets that are held jointly with you and your child. So, you know, we want to avoid that situation. And two, when you die, you get something called a step up in basis. For a stock brokerage account, if you name that child as joint account holder during life, then they're only going to get a step up in basis of half of those assets. Whereas if you wait and make them a beneficiary of that account, then upon your death, the assets receive a full step up in basis. So if you have an account with stock holdings that you purchased many years ago, and maybe the total basis and all of that stock at the time you purchased it was $100,000, and now it's worth $1 million at the time of your death, your child is not going to be taxed on that income, that capital gain, between the time that you purchased stock and the value that has increased at the time of your death. So with a transfer on death beneficiary form, they get that full step up in basis, whereas they would not if you make them a joint account holder during your life. Okay, Lori, do you have any other thoughts on that?
Just to go back to your question about, we always talk to our clients under estate planning about, okay, where is the cash going to come from in your estate? Let's say, you don't have any children, or you, something were to happen to you and your child at the same time. Where is there liquidity in your estate that's going to pay for those expenses at death, funeral expenses, and carrying costs for a house, paying the mortgage and things until the house is sold, all of that. So oftentimes we have parents that have one child or maybe two, and they'll name both of their children as the POD on the account, and they will count on the idea that their children will use that money to pay for those expenses. And then they'll get the rest of their inheritance when probate is through. So it is a mechanism for doing that. If you have, the other thing I would add with regard to naming a child as a payment, POD, a TOD, or as a joint account holder, if you have more than one child, that child that's named as the beneficiary of that account, it becomes their asset upon your death. They don't have to share it with their siblings. And in fact, and this kind of leads right into the next thing I'm about to talk about, if they do share it with their siblings, they either, there's a possibility they have to disclaim it and give it back to the estate, which may mean probate has to happen when it didn't have to happen before, because the beneficiary designation should have worked. And sorry, I'm getting a little more complicated with this, but the other piece is that if they give, let's say it's a $50,000 account, and you leave just that account to one child, they're either a joint owner on that account with you, or they're named as a POD, that $50,000 becomes that child's asset. And if that child says, well, I know mom didn't really want that to happen, she wanted me to have 50%, you to have 50%, let's say you have two kids. And so she gives $25,000 from that account to her sibling. Now she's got to file a gift tax return because she's given more than $16,000 away to somebody. So it gets complicated when you have more than one child. It's just, and it's a good practice to have, whether you're sitting down with us or you're sitting down with a different estate planning attorney, but to make sure that you have that conversation in your meetings with your estate planning attorney about, how things are going to get paid for, how your accounts are titled. We make sure that every one of our clients that leaves our office gets a letter that says, this is how you need to set up your beneficiary designation so that it matches your estate plan and doesn't circumvent everything that you worked on in creating your will because you put the wrong person or just one person as a beneficiary on an account. So going back to the update part, one other thing that happened this year is it's been static for a little while, I believe, where gift tax returns were required to be filed if you gave somebody more than $15,000. It has just gone up to $16,000 this year. So it's a little, and that's an important tool in your estate planning toolbox, if you will, is whether you wait to gift money to a grandchild or a child until after your death, or whether you start giving money away to them during your lifetime. And how do you do that? So that's part of what an estate planning lawyer will talk to you about and how that might work in your plan. The other thing that went up hand in hand with the gift tax number threshold is your generation skipping tax threshold as well. So as of last year, it was $11.07 million. So if you had an estate that had $11 million or less of assets, no estate tax would need to be paid upon your death. That number has now been increased due to inflation up to 12 million. It's 12.06. And it's set to sunset in 2025, back down to a number that's going to equate to about $6 million. We can have an all-day conversation about whether that's actually going to happen or not. But if you have an estate where you believe your assets are more than $12 million, you need to talk to your estate planning lawyer about some tax planning as part of your whole estate plan. And if, as we come closer to 2025, maybe you have half that in assets, you're going to want to talk to your estate planning lawyer to figure out if there has been a change in the law, whether it is actually going to sunset, and whether there's any planning you need to do for that. Any questions related to that? Okay.
So the.
Yes, I have a question. I have a question.
Sure, 1 second. I just want to clarify. So the sunset provision occurs January 1st of 2026. So when we say 2025, it means it goes through the end of 2025 and then it sunsets. Yes, ma'am.
I understand there's a new law now that if you inherit an IRA, that you only have 10 years to withdraw the entire amount. Is that true from a parent, for an adult child inheriting from their parent?
That is correct. And I'll repeat the question so everybody can hear. She just asked if there was a new law that for retirement.
There is a new law.
There is a new law. It's called the Secure Act. Secure, SECURE Act. And under the Secure Act now, for a qualified retirement account, a spouse still is able to stretch out over their lifetime the required minimum distributions. But an adult child has 10 years to take those distributions. And you know, depending on what their tax advisor may recommend, they may take it in increments over those 10 years or take it all out at the 10th year. But that is correct. That is a new limitation for the retirement accounts.
Another question. So I've been here with Denari with my mother, and it's been about 10 years since she's passed away. So anything is that I would have to take that full amount at the end of 10 years?
No, it depends on when your mother died. And because the Secure Act just went into effect, I think it was in 2020. So if she died previous to that date, then you're bound by the previous statute that allowed you to take those required minimum distributions over your lifetime. Any other questions? Okay. So let's talk about events that can occur that you would want to relook at your estate plan. Generally, we always want to look at your estate planning documents every 5 years, just so that A, you can confirm that you know where they are. Sorry, okay. But B, so that you can look at those provisions. You know, has your financial situation changed so that if you have a lot of specific or general bequest of money that you're leaving to people, do you still have the assets available to be able to satisfy those bequests in your will? Have your beneficiaries changed? Is there somebody that you want to take out of the will or put into the will, or a charity as we age? We often think more about charitable bequests. The other thing is, have the people that you've appointed as either executor or trustee in your will, are they still able to act in that capacity? Or has something happened, either a family circumstance or with their own physical or mental state, that you might want to name somebody else as executor or trustee of your will? Have your children had additional grandchildren that may not have been contemplated when you first executed your will? You would want to make sure that the provisions of your will would allow, if you so desired, for those new grandchildren to share according to your wishes with the other previously born grandchildren when you executed your will. And that could be for adoption as well. Generally in Georgia, if you've adopted someone under the age of 18, they are deemed to be your legal heir. And so just a few things to think about, every 5 years, definitely look at the will. If there's a major tax change in 2026, you think it's going to be fine, but that would be another reason to go to your financial advisor and estate planning attorney to look and see if you need to think about some ways to reduce the tax burden.
And I'll add to that. I know we're running short on time. I think we're good. Oh, okay, wonderful. I will add to that if your overall asset portfolio has changed and all of ours do over the course of our lifetime. Sometimes we own a house, sometimes we don't. Sometimes we have a car, sometimes we don't. As we age, those assets tend to change, and no longer own real estate and all you have are financial accounts. That's a good time to think about meeting with an estate planner to figure out if there's a way to set up your estate so that your children, your executors don't have to go through probate, that we can just handle everything through beneficiary designations. But what your overall portfolio looks like is also something to pay attention to and could be a good trigger for when you should update your estate.
Yeah. Along those lines, also in looking at your estate plan, it's so important to check in with your financial advisor. Make sure that the beneficiary designations that you have instructed and have given are actually on the account. It's very rare, but it does occur where something falls through the cracks where you submitted your beneficiary form and it doesn't get into the system correctly. So you always want to confirm that that has been done. And that there's been a change in your beneficiaries, that it's still the way it's set up that you want it to flow. Yes, ma'am.
I have a question that I'm not sure I know exactly how to state it, but I have a brokerage account and I have listed someone as the recipient on my desk. Is that passive, that will pass outside of probate?
Yes, ma'am. So she has a brokerage account and she has listed someone on her account who will receive those proceeds of that account upon her death. That will pass outside of probate. It will pass directly to them upon presentation of a death certificate. Oh, that's a great question. There are lots of ways to avoid probate. One is through beneficiary designation. The other one that estate planners will use is something called a revocable trust, where during your lifetime you title assets into a revocable trust that's used during your lifetime for your sole benefit, and then upon your death, the trust distributes the assets according to your wishes, just as a will would, without the need to go through probate. And we've had, I think, a seminar before that we've given on revocable trust, and maybe we'll do another one in person very soon, if that's something of interest to people.
I don't have any children. I have 4 siblings. For a benefit designation, is there a way I can word something like divide it equally between the surviving siblings.
Yes, there is. And so your financial advisor at any brokerage account can help you with that beneficiary designation, but you can divide it among your surviving siblings equally. Yes, ma'am.
Is there a difference? I mean, I hear people talk about having a trust. Is that the same as a revocable trust?
There are different types of trust, and so a revocable trust is one that gives you a lot of flexibility because you can't revoke it at any time. And it's used during your lifetime. You don't have to set up a separate tax number or an EIN number for that trust. It's just reported under your social security number. So for convenience purposes and to avoid probate, that's probably the type of trust that you've heard the most about. There are also irrevocable trusts that sometimes are used for tax purposes, such as something referred to as an ILET, which is an insurance trust, where you are purchasing an insurance policy to be able to offset tax liability that your estate might have. And that is something that's an irrevocable trust that cannot be altered or revoked in the same way that revocable trust can be. So there are different types of trusts.
So if you, one of the good reasons you may have just said this, or setting up a trust rather than a simple will, I mean, especially if you don't have, millions of dollars or something.
So if you're setting up a trust because it's not because you have a taxable estate, what would be the other reasons for setting up that revocable trust? One would be is if you have property outside of the state of Georgia. That way you could avoid not only probate in Georgia, but also in the other state. We see a lot of people who have property, for example, in Florida. Florida is not a good state to have to go through probate. So we'll often use a revocable trust, even though they don't have a taxable estate, so we can avoid probate in both places. The other reason to use a trust is sometimes just for confidentiality. Your will, when it's probated, is put on the public record. So, anybody can have access to the details of that will. In Georgia, we're not yet all online, so it's not quite as easy to discover as in some other states, but oftentimes for privacy reasons. And then the third reason is if you have an heir that you're concerned might object to provisions in your will. Either you're not leaving the heir the same amount as your other heirs, or you're cutting them out altogether, then we will often recommend using a revocable trust because that's to avoid probate, so that heir is not required to consent to a probated will.
I'll add one other thing to that. Capacity planning. If you have a diagnosis or are concerned about a future diagnosis where you may have capacity issues going forward, it allows for the seamless management of your assets without having to go through probate. So it's a good way, while a power of attorney also allows for somebody to manage your financial affairs in the event that you become incapacitated. If it is more of a long-term situation and your money needs to be managed for you over a long period of time because of an impending diagnosis, a trust is a great way to handle that for capacity planning as well.
Do I understand it correctly that to have money to bury you, expensive, like to bury, that if you have a trust, the trustee can have access to the money right away. Where if you just have a will, you have to wait for it.
That is on a very simple level. I think what you've said is true, that if you have a trust, it allows somebody to have access potentially to money right away, as versus if you have a will, they may have to wait for probate. It really depends on how your accounts may be set up. If you used a beneficiary designation to allow somebody to have immediate access to an account, that may be a way to do it if you just had a will. Any other questions? Victoria, how do we see the online questions, or how do you want to address those? If anybody has any, let's just say non-specific questions, nothing specific related to your individual assets, it'd be better for you to contact us individually with those. But if you have general questions, please, anyone who's watching on the Zoom, and thank you for joining us. And for those of you that are headed out, thank you so much for coming. We really appreciate you being here today and welcoming us.
And I'm just letting, I want everybody to say, if you've got questions, if you have anything else to say, but I want to encourage people, first of all, numerous people walking out the door, this is very helpful. I want you to know that back here on this table is that we have their cards, we have other things that have their information. It's really important to have this. And if you forget and you don't have it, you lose it, email me, I'm always glad to send it to you. But they also were generous enough to bring us all stuff.
Thank you, Victoria. Thank you. Is there anyone else on the Zoom that has questions? Okay, well, again, thank you so much. And I'm gonna pass to you.
Well, thank you. I was just gonna say, if any of you have a specific topic that you would like for us to cover the next time that we come, please tell Victoria what you would like us to talk about the next time. We're happy to come and visit, but we always want it to be a valuable hour of your time and the way it's spent. Thank you.
Thank you so much. We don't want to wear you out either, so we're gonna have to figure out how often.